love posting details about our life on social media, right? Exchanging text messages, photos, and videos in a pace that's practically impossible to keep track of. And while we do that, there's one thing we all want. Lots of attention? Well, no. Safety of our personal data. We live in a world where our data, personal interests, and financial data are the most valuable things. Ever wondered why you see certain ads on your social media sites? Maybe something you were shopping for earlier or something that seems oddly targeted to you. Amid a fast-paced internet world, consumers have been generating a lot of data, which has allowed companies to show them personalized advertisements based on their browsing patterns and other online behavior. But while that happens, do you know that companies store a lot of these data sets without taking your consent and don't even take responsibility when the data leaks? To hold such companies accountable, the government in 2019 tabled the Personal Data Protection Bill for the first time. While there is no express legislation or a law in India dealing with data protection, in this video we'll take a look at what this Personal Data Protection Bill is and what it means for you. It was only in 2019 that a Personal Data Protection Bill was introduced in the Lok Sabha. The bill was necessitated by the Supreme Court judgment on the right to privacy. India had banned several Chinese mobile apps in 2020. This was also one of the reasons why the need to protect data of Indian citizens had acquired greater urgency due to a tense border standoff with China. A Joint Parliamentary Committee or a JPC was set up in 2019 to study the provisions of the bill and give its recommendations, and it submitted its report on November 22. Before we understand what this bill is all about, let's give you some context of what authorities in India have felt about data and privacy over the years. In 2017, the Supreme Court of India recognized the right to privacy as a fundamental constitutional right and directed the government to create a framework to protect citizens' data. In 2019, the government introduced the Personal Data Protection Bill that set the basic ground rules for how personal data should be collected and stored. It also proposed the creation of a new regulatory agency, the Data Protection Authority, which would monitor the implementation of the law. Cut to now in 2021, the bill is slated to be tabled in the winter session of the Parliament. While we do know that the bill aims to protect your data, it's important to understand what kind of data falls under its ambit. The bill sets up three different categories of data: personal data, sensitive personal data, and critical personal data. Each category of data carries with it separate obligations and regulatory requirements. Indian companies as well as foreign companies dealing with data of Indian citizens will have to comply with this. Personal data is data which pertains to characteristics, traits, or attributes of identity which can be used to identify an individual. Sensitive personal data includes financial data, biometric data, caste, religious or political beliefs, genetic data, or any other category of data specified by the government. Critical personal data means such personal data as may be notified by the central government to be the critical personal data. The bill governs the processing of personal data by A. Government, B. Companies incorporated in India, and C. Foreign companies dealing with personal data of individuals in India. Simply put, the bill requires companies to tell you about their data collection practices and seek your consent and store evidence of such consent. Create a system that allows you to withdraw your consent, give you the right to access, correct, and erase your data. Make changes to protect your data better and in a manner where privacy is a key consideration in how the business is organized. Ensure all sensitive personal data is stored in India and that critical personal data is not transferred out of India. But what does the bill say about transfer of data outside India? As per the bill, sensitive personal data may be transferred outside India for processing if consented to by the individual and subject to certain additional conditions. However, such sensitive personal data should continue to be stored in India. Certain personal data notified as critical personal data by the government can only be processed in India. The JPC in its report has even said that the centre must ensure that data localization is followed in letter and in spirit by all local and foreign entities. And India must move towards data localization gradually. But what is data localization? Anytime you provide your data to something, it needs to be transmitted, processed, and stored. It is highly likely that the data is not stored in India but elsewhere. Data localization would imply that this data would have to be stored within the physical confines of the country by the entity that is collecting your data. This bill doesn't have strict restrictions on data localization and allows them to process elsewhere. It has only put curbs on sensitive personal data, which must be stored in the country but can be processed elsewhere pending approval. This bill is essential because it determines who has access to what data, what and who is exempt, what the penalties are, among many other things. While this bill has provisions in place to protect data, let's understand what it means for me, you, and several other stakeholders. As users, we all want control over our data. This includes knowing who's collecting data, where it's being stored, how it's being used, and what can be done if it's misused instead. The Personal Data Protection Bill brings with it the right to be forgotten, where we can restrict the disclosure of our personal data. You and I can erase our personal data. However, this is subject to certain conditions, such as when the data is no longer necessary for the purpose for which it was processed. One of the primary criticisms of this bill that has come up recently is the amount of power it gives to the government. The bill allows the government to process personal data without consent in cases where the government wants to provide a benefit or service, issue a certification, license or permit, to comply with a certain court order, to provide medical treatment and health services, to ensure safety during any disaster or any breakdown of public order, among others. The bill comes at a time when similar legislation is being introduced in other countries that seek to maintain the right to privacy of citizens in a digital age, where companies seek to track every piece of information of citizens for their own gain. With JPC's report out and the bill being all set to be tabled in the winter session of the Parliament, it is to be seen if the Personal Data Protection Bill of 2019 can produce similar levels of success.